Thank you, Dean Donovan. It's always a pleasure to be here at Mercer. Well, hello and congratulations. Only a few more hurdles and you will be lawyers. This time, a year from now, you will be awaiting your bar results. Bar results come out on October 30th this year. This law school had a 95.8% pass rate for the July 2008 bar exam, Georgia bar exam. So, you have a very, very high chance of passing our exam with flying colors. Now, back to another hurdle. I'm going to talk about the fitness process today. As you all know, bar admission in Georgia is a two-step process. Unlike Florida, where you can go ahead and take the exam before you have been certified as fit, you must receive your fitness certification in Georgia before you may sit for the exam. I'll be back in April with a bar examiner to talk about the actual bar exam, and he or she will go over the question that was written for the exam last time. But today we're focusing on fitness. I want to demystify the process for you. I want you to go into it knowing what to expect, so there'll be no surprises. I'll go over the process and then I'll take questions. Let me say right now, if you have a question about the VISTA incompatibility, Chris is working with my staff on that. Where we're going right now is we're going to an online application that will be submitted online. It was supposed to have been ready October 1st, as these things happen. It is not. They're telling us November. What you need to do is watch our website, because we'll give you notice when the online receipt of the application is available. In the meantime, as I said, Chris is working with my staff about the VISTA compatibility. The deadlines and other information that I'm going to talk about today is on our website, so you can just sit back and listen. You don't have to take notes because everything is there at www.gabaradmissions.org. Now, I will talk about the Georgia process. I'm well aware that not all of you will be taking the Georgia bar exam, but every jurisdiction has a fitness process. Some may not be as rigorous as Georgia's, but everyone has a process. As you know, it is the process by which the fitness board, the board to determine fitness of bar applicants, investigates whether you have the character and fitness that are requisite of members of the state bar of Georgia. As Dean Donovan pointed out, this is a high standard. I have a very good friend whose name is Bill Smith, recently succeeded by Paula Frederick, and Bill was, Paula as of last week is, the general counsel of the State Bar of Georgia. The fitness board and I do not want to give them any problems, and that is what we try to do through the fitness process. The board's responsibility is to protect the public from unethical, unfit lawyers who do not have the requisite character. That is the prime responsibility of the fitness board. Now, we do have a responsibility to give you an efficient, respectful process, but always bear in mind it is the public protection that is the main priority, because after all, that is who we serve. Those applicants who demonstrate to the board's satisfaction, and the burden is on the applicant to prove that he or she has the character and fitness required of a member of the state bar. Those people will be certified to take the bar exam. You all may remember that I was here when you were first years, and basically the message then was keep your nose clean, be aware of what is required of the character and fitness process. And so 2 years later I'm here, and now's the time to see if you took that message to heart. A lawyer's reputation is his or her stock in trade. A reputation is very hard to earn and very easy to lose. I think I told you 2 years ago that your reputation is your most valuable asset as a lawyer and that you are building those reputations while you're here in law school, because these are your professional colleagues the rest of your lives. The members of this faculty and staff are well respected in the Georgia legal community. And what goes around comes around. The world is very round. Your credibility will be on the line in the fitness process. We used to say that character is what you do when no one else is watching. Well, now everyone can watch, thanks to the internet. You need to be aware of what you put out there in cyberspace, the public arena. Now, so far, the Georgia Board of Bar Examiners and the Fitness Board have decided not to do a routine check of social networking sites. However, I just heard that the Florida Board of Bar Examiners recently decided to do that on a case-by-case basis for those whose applications reveal problem areas. Many employers today are doing this as well, checking social networking sites. Now, filing deadlines. The regular deadline is December 2nd. The late deadline is March 3rd. If you file late, you will pay a $400 late fee. The exam, the deadline is June 4th. The dates of the exam are July 27th and 28th. My advice to you is file by December 2nd. You save $400 and you have a better chance of getting through the process quickly. The fitness application fee is $500 while you're still in school if you file by the first deadline. The exam application is $350 to the Georgia Board of Bar Examiners and $76 to the National Conference of Bar Examiners for their part of the exam. So it's a total of $426 for the bar exam fee. There's another fee of $100 to take it on laptop.
As opposed to what?
Handwriting.
She said not to take notes.
You can take notes, but it's not necessary. It's all on the website. Are all of you planning to take the Georgia exam? Raise your hand if you are. So not quite everybody. Okay. Thank you all who are taking other jurisdictions. I hope you'll learn something. Is anyone planning to take the February 2010 exam? Well, that's good. The deadline for that's coming up next week. How many of you have actually filed your applications? How many of you have started working on it? Good. Thank you. You're doing yourselves a big favor. The application is available on the website, and before starting your application and before you ask any questions about the application, you need to review it and read the policy statement regarding character and fitness reviews, the frequently asked questions, and there is an article on the website called Admission to the Bar, Character and Fitness Considerations. A lot of your questions are answered if you will read those documents, and you are required to read those before you start filling out the application because it will tell you what you can expect. We don't want you to have surprises. If you have bad credit problems right now and you don't see that you can solve those problems in the next few months, you just don't need to be thinking you're going to take the July bar exam. And there's no reason to come up and act surprised about that because the policy statement is very clear on that. If you receive a DUI in your third year of law school, forget taking the July bar exam. The policy statement is very clear about that. My advice to you is to begin working as soon as possible on it because it is a long, very involved application. You've got to remember you can't get to that bar exam until you pass certification. Now you can submit, what you would normally do is submit a printed copy and some media, external media, USB key or a diskette. If you want to wait until November, when we hope to have the online application available, you can file it online. As I said, watch our website for that. The application is intrusive. It asks a lot of very, very personal questions. I want to assure you that all of that is kept in the strictest confidence. We can't even reveal to your parents anything about your application. I get calls frequently from judges for whom some students have worked, and they want to know something about the application. And I have to tell a judge, Judge, I'm sorry, there's nothing in the file giving me authorization to speak to you. I have to have your written authorization with an original, not fax, signature. So do not fear that anything you put on your application is going to be disclosed without your permission. You need to read the questions carefully and answer them forthrightly. Do not read the questions as though you're a lawyer. Answer them fully and completely. As I have said, credibility and candor are of prime importance. And if you don't disclose something, the fact that you didn't disclose it can be a disqualifier more than the actual fact that you didn't disclose. So when in doubt, disclose. Once you file your application, it will be reviewed for completeness. You will get a call if something is missing. If it is complete, you'll get what we call a startup letter, basically saying we've received it, and we want additional information about something or not. It's going on to an application analyst. We may ask you for additional information. You're asked to provide a narrative about certain problem areas, and if your narrative is very short, such as we had an applicant who was arrested for DUI, but instead of saying arrested for DUI, the situation was I had not eaten enough, and what the kind of things people usually put. He just put the code section. So he got a letter saying, please provide a full and frank narrative of all the facts and circumstances. Now, when your application is complete, it will be given to what we call an application analyst. These are the people who will actually do the background investigation. They're all women right at this point, so she will send you a letter introducing herself, giving you her phone number, and let me tell you, this is your best friend in the fitness process. She will guide you through it, she will help you through it, and you need to listen and pay attention to what she's telling you. She will confirm all the information on your application. She will check with your references. She will check with all your schools, your employers, all of the relevant parties, criminal agencies, your creditors, etc. You can speed up the process by asking these folks to respond as quickly as possible and by giving up-to-date, current contact information. Many times your application is held up because your references do not respond. So at some point, the application analyst may call you and say, would you please get your employer or a personal reference to respond? Once we're completely online, you will be able to go in and look at your status and see what references have not responded, so you'll know what to do and what's holding things up. In the meantime, you can call your analyst. Once all the information is gathered, the file is reviewed for problem areas. If there are no problems, the file is sent to the fitness board to review for certification. If you file on time, that is by December 2nd, and your application is complete and there are no problems, you should hear within 90 or 120 days that you've been certified. And that certification is good for 5 years. If you think you're going to take the Georgia bar exam and you get a job offer in Florida, your certification is good here for 5 years. So the only thing you need to do to keep your certification up to date is to let us know any changes of address or marital status or anything that would change from your original application. Okay, if there are problems and the file is complete, the fitness board will review the file and make one of three choices. It can review the file and say, okay, this person has explained fully and frankly the problem areas, the problem has been resolved, and we'll certify them anyway. 80 to 90% of you fall in this category or the category of no problems. Or the fitness board can look at it and say, you know, we need more investigation. We're not sure that we can certify until we have more information. Or, for instance, they could send you out for an alcohol evaluation. If you have a string of alcohol-related offenses, you can be sent at the board's expense to a psychiatrist who specializes in substance abuse and addiction. Or the board can say, you know, we want to see this person. We will invite them in for an informal conference. So those are the choices the board has. In a typical year, 40 to 50 people are invited in for an informal conference with the fitness board. At the informal conference, the board can take one of several actions. Now, the informal conference is not a hearing. It is not a deposition. You have a right to have a lawyer there, but the lawyer is not allowed to say anything because the fitness board wants to assess your candor and your credibility. I cannot tell you how many times an applicant has presented some problem areas. And even in the applicant's written explanations, there still remain questions. But the applicant comes in and the board, made up of 9 people, 6 of whom are lawyers, 1 is a psychiatrist, 1 is a management consultant, and 1 is an English professor here at Mercer. And the management consultant is also in the Mercer area, in the Macon area. These are pretty wise individuals, and they will assess the credibility. And many times, someone who doesn't look that great on paper can come across as credible, responsible, having learned from mistakes. So if you're invited in for an informal conference, it is your opportunity to convince the board that you have the character and fitness that you need to have. Okay, once you have had your informal conference, the board can table the application until some other investigation is made or until the applicant accomplishes or achieves certain things, such as has more time to show rehabilitation. I'll talk about rehabilitation in a minute. It can tentatively deny the application. A tentative denial triggers your right to a hearing before an impartial hearing officer. And then that is a hearing and you can have a lawyer. We have 5 to 10 a year that are tentatively denied. The formal hearing process results in a decision by the hearing officer, but it is not binding on the board. The board can either accept, reject, or modify the hearing officer's decision. Any adverse decision after the hearing officer's report can be appealed to the Supreme Court of Georgia. If you are denied, you must wait 3 years before filing again. Or the third action that the board can take is to, as I said in the case of the person that I was talking about, the board can certify you and you're on your way to the bar exam. Now, are there any questions so far about the process? Okay. All right. I've mentioned problem areas. Exactly what are the problem areas? Well, you can find those out on our website by reading the policy statement regarding character and fitness reviews. And I'm going to read them to you. Unlawful conduct, obviously. Academic misconduct, including plagiarism. Making of a false statement, including omission of relevant facts in the fitness process. Misconduct in employment. Acts involving dishonesty, fraud, deceit, or misrepresentation. That phrase is going to follow you throughout your life as a lawyer because that's prohibited by the rules of professional conduct. Any act involving dishonesty, fraud, deceit, or misrepresentation. Another problem area is abuse of legal process, neglect of financial responsibilities, especially failure to repay student loans, neglect of professional obligations, violation of an order of a court, especially failure to pay child support. That follows you as a lawyer. Evidence of mental or emotional instability. Most of these do follow you as a lawyer. Evidence of drug or alcohol dependency. Denial of admission to the bar in another jurisdiction on character and fitness grounds. Disciplinary action by a lawyer, disciplinary agency, or other professional disciplinary agency of any jurisdiction. Okay, now what you need to know is the good news. It is your current character and fitness that are important, not what your character and fitness were 5 years ago. The board looks at current character and fitness. Also, the board believes in the concept of rehabilitation. Any conduct can be the basis for rehabilitation. You can always show your rehabilitation. But the board looks carefully at these problem areas, especially as they relate to your trustworthiness and your honesty and integrity. The board applies criteria. The recency of the conduct. A DUI at 18 is no big deal. A string of DUIs from 18 extending into law school is a very big deal. Your age at the time, the seriousness, patterns are important. But most important is evidence of rehabilitation. It is the board's position that there is no conduct that represents an absolute barrier to admission. Let me give you an example. The board certified a person who had been convicted and served time for committing 6 armed robberies. That person was certified. Another person was convicted of plagiarism in law school. That person was not certified. What's the difference? The second one could not explain how the plagiarism occurred, professed not to know what plagiarism is, blamed other people, and took no responsibility whatsoever for the situation. The board determined that that person was going to be a danger to the system, more so than the person who had paid her penalty dearly, but showed great evidence of rehabilitation and taking responsibility. Now let me tell you how the board handles a problem area. And I'm going to use alcohol because it tends to be the most frequent problem area. If the applicant shows a history of alcohol-related problems and offenses, we would ask the applicant to give a statement. If we remain concerned, we would send the board would decide to send the applicant out for an alcohol evaluation at the board's expense. If the psychiatrist says, yes, there is an abuse issue here, this person needs to be in treatment, the board would table the application for treatment and ask the applicant to have the treating physician or the treating therapist file quarterly reports with the board for some period of time, at the end of which the applicant would be invited in for an informal conference. And that would be the time at which the applicant, together with the quarterly reports, would have the chance to be certified. We actually had an applicant who came back and thanked the board. He had an addiction issue, and he would not face up to it. But because he wanted very badly to be a lawyer, he was willing to go into treatment. And he came back 18 months later and thanked the board for holding him out. He said his whole life, all of his personal relationships had improved. Okay, as I mentioned, the biggest single problem we see is alcohol. DUIs. They are criminal conduct. They show a disregard for the law, and they are a huge societal problem, putting you and others at risk. Second major area is credit history, financial irresponsibility. defaulted student loans, liens, charged off accounts, accounts that have been put out to collection. I know in this day and age, it's going to happen. We're seeing it happen more and more frequently. But after all, a lawyer is charged with a trust account handling other people's funds. We have to be convinced that those that are certified can handle financial responsibility and access to funds appropriately. I'm not saying no debt. Debt is okay. Irresponsibility about debt is what can hold you up in the process. If there are credit problems, the board requires that you enter into an agreement with your creditor and be able to show 6 current consecutive months of on-time payments as agreed to with the creditor. We have people who don't think we really mean that, and they get to May before the bar exam in July, and somehow they're able to borrow enough money that together makes, say it's their payments are $100 a month. They find someone to loan them $600. They make that one payment and they say, okay, 6 months, payments on time. 6 current consecutive on-time payments. You can't do it all in one sum at one time. We want to see a pattern of responsibility. And we want to see that pattern continue after the bar exam, because after all, you're under the jurisdiction of the fitness board until you're sworn into practice, and then you're under my good friends Paula and Bill. The third area we see a lot of, problem area, is academic misconduct. Plagiarism, school suspension, and expulsion. By the time you are in law school, you need to understand what plagiarism is. And if you don't, I know Dean Donovan can explain it to you. So you just be aware. I don't know what plagiarism is not a credible defense before the fitness board. Recently, the Supreme Court of Georgia upheld the board's and the hearing officer's decision of denial of certification of fitness to an applicant who was convicted of plagiarism in law school, and he could give no plausible reason why he had committed it. Again, rehabilitation is the key. If he had said, I was under pressure, I was going to fail, I felt I had to do this, he would have been a lot farther along in the fitness process. Now he's denied and he's got to sit out 3 years. Now, a word about mental health issues. If you have had counseling for stress or grief or domestic issues, do not be concerned about that. That is healthy, that is good to do, and the board is not concerned with that kind of counseling. There are some mental health, 3 mental health questions on the application, but they ask about more serious mental health issues. The board encourages treatment for any mental health issue, just as you're encouraged to get treatment for any physical illness. The mere fact of treatment for a mental health condition has never been held against an applicant. In fact, the fact that someone has a mental health issue and did not get treatment has worked against the applicant. To date, the fitness board has never denied anyone on the basis of receiving treatment for mental health issues alone. Further, the board routinely certifies applicants who have demonstrated personal responsibility and maturity in dealing with mental health and addiction issues. It on occasion does deny certification when there is a problem, it's been diagnosed, and the applicant refuses treatment. This is consistent with the public purpose that the board needs to protect the public. Now, I've mentioned the DUI policy. The DUI policy follows the statute in Georgia. The DUI statute in Georgia mandates a 12-month sentence. Whether or not it's probated, whatever, suspended, it is still a sentence. If you are serving a sentence, you are not eligible for certification of fitness to practice law. If you have pending charges, you are not eligible for certification of fitness. And remember, you're not in control of how long those charges are going to be pending. You don't know how long before it can come before the court. So we've had people who've been held out a long time because of court calendars. Now, this is applied to a DUI received in any jurisdiction as well. Another jurisdiction may not have the mandatory 12-month sentence, but if you receive a DUI in South Carolina, you will be held to the Georgia standard of 12 months from the date of conviction. You are not eligible for certification of fitness. Now, the board has also noticed a disturbing trend of people who have gone to judges and said, "Judge, you've got to reduce my DUI charge to something less, usually reckless." And a lot of judges will do that. And the fitness board, on whom sit 2 state court judges who see this happen a lot, they won't reduce it, those 2. Judge Del Campo in DeKalb and Judge Patsy Porter, who's chair of the board in Fulton. You don't want to come before them asking for a reduction. At any rate, if you have been charged with DUI and it has been reduced to a lesser charge, then the board applies the 6-month policy. So you're not eligible for certification for 6 months from the date of conviction or for the term of the sentence,
Is
whichever
that all
is
jurisdictions
longer.
too, or that's all jurisdictions also?
If you receive a DUI in another jurisdiction and it's reduced to a lesser charge. Now, if you are arrested for reckless, and there's no alcohol involved, this doesn't apply. It's just if you are originally arrested for DUI and it's been reduced. Okay, how to avoid a denial of being delayed in the process. File early, file a complete application, read the policy statements about areas of concern, and be aware that if you have one or more of those, there will be further inquiry. Be prepared to respond quickly when we ask you for information. Cooperate. Be conscious of how you relate to your analyst. If you are uncooperative, rude, or not forthright, it will be noted for your record. After all, the fitness process is an early indication of your professionalism as a lawyer. We've seen a bothersome trend over the past few years of people with problem areas waiting until the late deadline, even though it's going to cost you $400 more. They think that their problems will go away, or maybe we won't have time to investigate. That won't happen. If we don't have time to investigate, the file is not complete. The investigation is not complete, so the file doesn't go to the fitness board. So if you have problem areas and you wait until the March deadline, be aware that there may not be time for you to get through the process in time for the July exam. The payment of a late fee is no guarantee that you will get through the process. Another troubling trend is ignoring deadlines. There are deadlines in the rules. There are deadlines in the policy statement. There are deadlines on our website. There are deadlines that your analyst will give you for the submission of information. These deadlines, contrary to maybe everything else in people's lives, we're like the IRS. The deadlines are firm. We have heard all the excuses. Oh, it was only a day late. Oh, I thought received meant postmark. Oh, you really meant that was a deadline. But you know, you've got to make an exception in my case. None of those excuses works. They don't work in court, and they don't work with us. If you would be seeking any accommodations on the bar exam, you need to call Ms. Allison. Ms. Allison is the person in our office in charge of accommodations, and you can write that down. One other bit of advice, and then I'll take questions. When in doubt, disclose. I have a son who is going to medical school, not law school, but he has a lot of friends who are in the fitness process in this and other states, and he knows the drill well. He tells them, as I'm telling you, disclose, disclose, disclose. Remember, some conduct that you don't disclose may not be a disqualifier, but the fact that you didn't disclose it could disqualify you. Remember that it's a continuing application. If anything changes from the time you submit it, marital status, address, another arrest, it needs to be reported to us. The results from the July exam are released in late October, October 30th of this year, so one more year for you. Do not engage in any conduct that will call your fitness into question. I'm going to tell you 2 horror stories. One is, after the bar exam, someone went out and celebrated and got drunk and got a DUI. Well, that person had pending charges, and that person was not allowed to receive his bar results because he had a pending charge. His certification was suspended. Now, I would be the last person to tell you not to go out and celebrate after the bar exam. Even the staff celebrates after the bar exam. But do not drink and drive. Then there was the applicant who got her letter from me saying, congratulations, you have passed the bar exam. Enclosed is your certificate of eligibility for admission to practice of law. This should be taken to a superior court judge for swearing in. Before she could get to a superior court judge, she went out and celebrated and got the DUI. Her certification was suspended because until that moment, when you're sworn in, you're under the jurisdiction of the fitness board. Now, the message is not go out as quickly as possible and get sworn in. The message is, because then you've got a whole set of other rules to go by, the rules of professional conduct. The message is celebrate, but do not drink and drive. You can attach extra sheets to your application if you need to. Don't think that, oh, well, I can't write a full and frank statement because there's not enough room. You can always write enough. For references, remember that your in-laws, your fiance, those are considered relatives. Your current roommate is considered a relative. Former roommates are okay. You need to give us your permanent and or temporary places of residence for more than 1 month in the last 5 years or since your 18th birthday, whichever is less. If you studied abroad and you can't quite remember, just do the best you can and indicate it was a study abroad program. Your employment should go back 10 years or to your 18th birthday, whichever is less. We ask for an official driving record from every jurisdiction where you have had a license during the last 12 months. It should be dated no earlier than 6 months from the date of your application. I'm told that one place in there it says 30 days, but it's 6 months. As I say, we are going to this new system and we are limping along with the old one, but your driving record should be no older than 6 months. Okay, questions? Yes?
I have a question about the accuracy of the driving record.
It has to be from the official state agency, not one of those online agencies. It has to be official.
So if we turn the driving record, but the driving record doesn't include something that you think should be on there, do you all just go for what the driving record says?
No, if you know that it's not accurate, then you write down. But I've got another speeding ticket that doesn't show on here.
Even though you don't know the date, you don't know anything?
Do the best you can.
Okay.
Yes.
If we can't remember one of the addresses we lived at, can we put like an approximate location?
Do the best you can. Yes.
Yes, for those who are U.S. citizens
Okay, we have a question. For those who are U.S. citizens?
but are born overseas, they have to get that consular certificate for birth abroad. What is that and how do we get that?
You need to talk with Ms. Hines, Hines. She is the person in our office who keeps abreast of the immigration rules. Okay, here.
What if you're born abroad but you were born on a U.S. Air Force base? Is it considered United States territory?
Yeah, that's considered U.S. territory. In the way back in the blue shirt?
That's bad. I was going to ask, this online thing we're talking about is going to be up November 1st. Is it
Well,
maybe
I'm not counting on it November 1st.
Well,
That's what they're telling us, but I'm telling you, watch our website.
And this is where I would go to answer all these questions on this website, so I can't do it until whenever.
No, you can do it now. You can file your application anytime.
But if I want to do it online, I have to wait for you guys to do that. Okay.
Now, when I'm saying online, that means it is transmitted online. Right now, we have what we call the online version, where you can type in and save it to a media. That's still available. That's always available. It's just the version where you click submit will not be available until November. Now, the red sweater.
A professor told us that when he took the bar, he had to get copies of all the speeding tickets that he's ever gotten, and he also mentioned something about getting letters from all the places he worked and saying that he didn't steal or anything. Do we have to do those things?
I would ask you to go look at the application.
Is that asked on the application?
Go look at the application and read the policy statements. I don't know when he was admitted, but this is. Yes.
We had employment when we were like 18, 19, 20. That,
Excuse
I
me?
worked at a store, and 2 stores that are no longer in existence. Do I still have to list those?
List those that indicate that they've gone out of business. Yes.
If we go through the process of getting ready for this and then we decide to sit for a bar in a different state, is there any way after we've gone through this process that can be kind of transferred to another state?
No, every state does its own fitness investigation. In fact, you'll have to put on the other state's application that you applied to us. Someone over here, yes.
Is there any agency or way to get information about employment history? Because the application asks for dates of employment, and I really don't remember the dates that I worked 5 years.
I'm not aware of anything like that. I'm
So
trying
what do we
to
do if we can't remember, I can't remember the exact date?
do the best you can. Okay. There were some other hands.
I have a question.
Yes.
It was a follow-up question to Heather's. If the company no longer exists that you work for, just put that it doesn't exist, you don't have to put the name of it?
Well, if you can remember the name, disclose the name if it were
I know, but when you are,
Irvin's or something.
but when you call to contact the company and they no longer exist, you just want to put in parentheses, they no longer exist.
Yes, gone out of business. And there were some questions over here? Yes.
So we got a speeding ticket, we need to wait for the disposition of the ticket before.
No, you don't need to wait for, you can just say pending. But once it is resolved, you need to amend. There is such thing as amending. There is a form on the website for amending, or you don't have to use the form. You can just write the board a letter saying, I hereby amend by stating such and such. It's very easy to amend. Yes.
Sorry, what if we don't know the supervisor's name where we work?
Do the best you can.
I mean, wait, the best I can say, I don't know, is that something the best I can?
Well, the problem you'll have is, it depends on how many employers you've had. If you've had a string of employers, 5 or 6, the fact that we can't get in touch with 1 or 2 of them is not going to be a problem. But if you've only had a couple of jobs and we can't get in touch with anyone, we've got to verify your employment. So the fewer jobs you have, the more important it is to give us exact names and contact information. Yes.
What sort of questions are you going to ask the employer? I'm afraid one of mine's lack of English speaking ability will make it difficult.
There are a series of questions, and then there's room for them to go on and tell us how wonderful you are if they want to. But the questions go to the heart of the matter. Is this person trustworthy? Would you recommend this person for a position of trust? Was there any discipline while this person was at work? Was this person discharged, terminated, asked to resign, any of that? And verify the dates of employment and that the person that you did in fact work there.
You have to get letters from anytime you're reported to a collection agency. Do the letters have to be current, or if you got a letter, like when you paid it years ago, can you use that letter from years ago? Do you have to get a current letter?
Okay, we check your credit report, And you all should check your credit reports, all three of them, just to see, you may have something on there you're not aware of in this era of identity theft. But if it's been resolved, it should show up on your credit report. If not, then you need to dispute it.
It's not on the credit report at all because it was over 10 years ago, but you say report all collection
Right.
agencies. So the letter's 10 years old, will you still take it?
Sure.
Okay.
Anything else? Well, I'll be back in the spring to talk about the bar exam.